Another week, another show. My hair's just gotten a little taller. Hey there, my ingredients. It's another episode of the Motley Stew show. I'm Luke Goldstein, your host, and this week we're back to the biggest and blackest robed court in the land, the Supreme Court. Obamacare is dead again? At least that's what people are hoping for who brought this case to the Supreme Court. We have 4 plaintiffs who are hoping to actually remove one of the very important elements to the Affordable Care Act, which would basically derail the entire thing. Oral arguments were heard this past Wednesday, and the 9 justices will now wait until late June to release their decision. They're also about to hear a deciding case about the constitutionality of state bans against gay marriage, but we'll save that for another episode. Now, last time the Supreme Court heard a challenge to Obamacare, it hung on the idea of whether or not the federal government could coerce or compel a citizen to buy something, in this case, health insurance. The challenged idea was around how people without healthcare coverage, or at least the minimum, would be charged penalties during tax time. The case went before the Supreme Court and famously fell in favor of the Affordable Care Act thanks to a last-minute switch, or some people call it a betrayal, of Chief Justice John Roberts, and he sided with the liberal wing of the court. Now, in Roberts' majority opinion, he said that the government does have the right to tax its citizens, and basically the fine that you found you would get if you didn't have the minimum requirements for health insurance could be decided and defined as a tax, which is actually something the Obama administration had been struggling long and hard to not do, but if that's how they win the case, they're going to take it. This time around, it's a little more nuanced. The case is over one line, just one line in a bill that had thousands upon thousands of pages. This is the phrase in question: an exchange established by the state under Section 1311. That's it. That one sentence could derail the entire Affordable Care Act. Or at least some people hope so. The argument being made by the plaintiffs is that that statement shows that the subsidies from the federal government going to the states to help them use Obamacare and the federal exchanges should only go to those states that have actually embraced Obamacare. The ones that haven't shouldn't get the federal subsidies, because that statement only refers to the state, not the federal government. So if you don't live in one of the states that actually embraced it, your healthcare coverage is about to go. Estimates range anywhere from 7 to 9 million people that would immediately lose their health insurance. Now, the effect of this would be catastrophic for those states, if not the whole country. And I'm not saying this as someone who likes to peddle in fear-mongering, or someone who just saying this because I believe in the law itself. I'm saying it because this is what the experts financially think. Here's how many of those experts see the breakdown if the Supreme Court sides with the plaintiffs. The subsidies to those people would end in days. Insurance premiums for those people would spike by 200+%. The markets in those states would be incredibly unstable because their insured pool would diminish rapidly, leaving those still with insurance to face even higher hikes to keep the companies afloat. The damaging effects would undoubtedly flow into the other covered states, causing a nationwide meltdown of the insurance market. Now, Justice Anthony Kennedy, one of the other possible swing votes, along with Chief Justice John Roberts, referred to this happening as a death spiral, not to be confused with death panels. That's something totally different. Let's not go back there. In essence, Kennedy's worry is over what he considers a constitutional crisis if they find for the plaintiffs. What the Supreme Court would be saying if it sides with the plaintiffs is that the federal government gets to tell the states who don't currently embrace Obamacare, either take it or we take all your money back and we destroy your state. That's coercion at the highest level. So Justice Kennedy seems really hesitant to go through with that. But he also surmised that if that's the way the law was written, then the court has no rights and no jurisdiction to actually rewrite it now. So both sides of this debate have something to hold on to in terms of Kennedy's vote. But here's the problem for the plaintiffs. The defense actually already has 4 votes, the liberal wing of the court. They have Sotomayor, Breyer, Kagan, and Ginsburg. Now the plaintiffs have 3 votes, Alito, Scalia, and Thomas, leaving Roberts and Kennedy in the middle. The government only has to get one of those people to vote with them. The plaintiffs have to get both. So it's a little bit more of an uphill climb for them. Now, before I go, I also want to mention some reports coming out about the 4 people who are the plaintiffs in this case. Remember, just because a state doesn't like Obamacare, they actually have to find someone who has cause, who has been directly harmed by a law, to actually act as the plaintiff in the case. So this conservative group scrubbed around and they found 4 people. who say that they have been directly affected by this case. Their claim is that the subsidies coming into their state actually push their income above the threshold to where they have to get health insurance. Otherwise, their income would have been so low that they would have been exempt. But what we've heard so far is that 2 of the plaintiffs are actually vets, so their health insurance is probably covered by the VA and they're exempt anyway. 2 down, 2 to go. The remaining plaintiffs both seem to have some sketchy details in their financial history, which may indicate that they don't actually go above the threshold at all, but who's to say? While this was brought up a little in oral arguments, it didn't seem like the defense of the government or the Supreme Court really wanted to go down this route. Now, why would you not want to do that if you were the defense? Because I don't think either side, the defense or the court, wants to just kick this case down the road on the basis of no standing. The justices on the court, especially the liberal ones, kept referring to this as just a redo of their case before, so I think they just want this over and done with. So how do you feel? Do you think the Affordable Care Act should be struck down because of the literal interpretation of one line in the bill? If you do think so, do you think that this government is actually going to be able to figure out a way of fixing it before the people whose healthcare is gone suffer? Let me know in the comments down below. Thanks for watching another episode of the Motley Stew Show. You can like, favorite, share, subscribe, all those fun things down below. You can become one of the new ingredients to the stew, and it's getting tastier all the time. Stay tuned for next week, and as always, a little bit of Logan. The argument being made by the plaintiffs is that that statement shows that the subsidies from the federal government going to the states to help them use Obamacare and the federal exchanges should only go to those states that have actually embraced Obamacare. The ones that haven't shouldn't get the federal subsidies, because that statement only refers to the state, not the federal government. So if you don't live in one of the states that actually embraced it, your healthcare coverage is about to go